Priceline.com has decided to evaluate their terms and conditions, and I've been assigned to analyze and perhaps overhaul the website's user agreement. Here's my analysis. Is it a valid contract? It is a valid contract, however, there are a few issues. Priceline is using old language along with others like Blockbuster, for example, which has left them open to have some clauses unenforceable. I'll explain in a moment. Are visitors bound to the agreements, or should they have to click an I agree button? Does anyone actually ever read these? In my opinion, I think websites should have users click I agree, which would act as a signature from their IP addresses. This then puts the responsibility back on the users because they can't say they didn't know. That would mean that they didn't take the time to read it, and this would then potentially protect the company from liabilities. According to Priceline's contract, it says, by accessing any areas of this site, users or you agree to be legally bound without limitation, qualification, or change, and to abide by these terms and conditions, which will constitute our agreement. It also says you should also read our privacy policy, which governs your use of this website and is referenced in this agreement. If at any time you do not agree with any part of this agreement, you must discontinue use of this site. Priceline.com reserves the right, in its sole discretion, to amend, modify, or alter this agreement at any time by posting the amended terms on the site. Again, who actually scrolls down to the bottom of the website to look at these terms and conditions? I know I don't. In an article from Forbes.com, are website terms of use enforceable? It discusses a case between Schnabel versus Triligent Core. The results provide an important part to answer this question. The case involves a father and a son who signed up for an online program, and after they signed up, they received an email with further terms and conditions that specified a mandatory arbitration clause. The pair canceled their membership and requested a full refund, and Triligent Core refused. Long story short, the Schnabel case makes clear that the website's terms of use that are available solely via a link in a small font at the bottom of a homepage without any notice to the users or reasonable manifestation of assent are unlikely to be enforceable. Another important part is that at the end of Priceline's opening terms, the conditions were where it says that they reserve the right to amend, modify, or alter the agreement at any time. Blockbuster used the same clause in their agreements. In a 2009 case, Harris versus Blockbuster Incorporated, it did not sit well in the courtroom. The judge noted that there is nothing in the terms and conditions that prevents Blockbuster from unilaterally changing any part of the contract, other than providing that such changes will not take effect until posted on the website. As a result, the court deemed the arbitration clause illusory, an odd Texas descriptor that appears to be a cousin of lack of consideration. Therefore, they threw out the arbitration clause. If you have a dispute with Priceline, can you sue them? Why or why not? With the above just being said, even though Priceline has a mandatory arbitration clause, this certainly can be used against them and allow them to be sued. The changes that I would recommend are updating the language being used unless there are mitigations in place that ensures that consumers are aware of terms like the click I agree element. For their protection and the company's, it's wise to have users click the I agree button for the terms and conditions each time they visit the site. If there are modifications to the terms, they can be highlighted at the top of the page to ensure that users are aware. No one scrolls to the bottom of a page to look at these. Although it may be annoying for consumers, providing transparency with them may help build their trust and loyalty. Thank you.